Hello, everyone. My name is Deep Sengupta, the CEO of DSG Global LLC, and welcome to today's presentation, Introduction to ITAR, the International Traffic in Arms Regulations. A little bit about DSG Global. We are a consulting firm focused on international trade compliance with um, offices around the country, such as Michael is based in Washington, D.C., and I'm based in San Francisco, and we have members in between. Um, a little bit about our services. We help our clients with all sorts of export control issues, including ITAR and the EAR, import compliance, cargo security, such as CTPAT, and a host of import-export issues in other countries as well. And of course, training. Today's training is going to be presented by Michael Slonim. Michael has more than 30 years experience in this field of export controls, covering not just the EAR, but ITAR, OFAC, the Department of Energy and Nuclear Regulatory Commission issues as well. And he recently retired after serving as the Director, International Trade Licensing at Honeywell. Michael is based in Washington, D.C. And Michael, over to you. And thanks for your time today.
Great. Thank you, Deep, for that introduction, and thank you all for joining. And welcome to the DSG ITAR overview. This is going to be a very high-level overview. We're going to concentrate primarily on some core concepts, the essentials of ITAR, including the importance of compliance. One point I think you'll get from this presentation is that there's no adequate one-size-fits-all approach to compliance. To that end, we here at DSG Global are available to address your specific business requirements, including targeted training, audits, assistance in licensing, assistance in registration, and so forth. Our team can create a workable compliance program customized for you. Just reach out to Deep or myself. So what is the ITAR? In a nutshell, the ITAR controls not only defense-related systems and components, but also defense services and data or technology. And ITAR is applicable to any person that is actually an individual or a company working in this space. So not just companies, but individuals. Whoops. The historical background of ITAR. So look, this could be very boring or it could be very interesting depending on how much you're into export compliance. But don't worry, I'm not going back to the Civil War or Trading with the Enemy Act in World War II. What's significant here is the 2009-2010 timeframe and export reform. Under ECR, many items of lesser significance were removed from the ITAR and shifted to the EAR under the commerce regs. It was a really good move, as the government likes to say they were building higher fences around more sensitive items or something along those lines. It did, however, make the jurisdiction and classification process a bit more complicated, as there are now military items under the CCL, the 600 series items that are under the EAR's classification system. So what are the core concepts? Really, it's pretty simple. It's not dissimilar to the EAR for those of you familiar with the commerce export regs. The bottom line is that if you're involved in any way with defense articles, that's anything on the U.S. munitions list, the USML, you have certain requirements to make sure you're not going to run afoul of the regulations. At a minimum, you'll need to be registered under the Department of State Defense Trade Controls. That's even if you're not an exporter, because Manufacturers of defense articles also must be registered. And moving to the next slide, there are a number of issues you're going to need to be familiar with if you're a manufacturer or an exporter of defense articles, including the fact that non-US persons can't have access to defense articles without an authorization. And failure to comply with the regs can lead to significant penalties. Now, under the ITAR, any of these ITAR-controlled activities require approval of some sort by the Department of State. This includes registration, as I mentioned, export licenses, or export exemptions. Let's talk a little bit about the ITAR versus the ITAR. We'll compare those. Well, the ITAR pertains to defense articles and is administered by the Department of State. The export administration regs are administered by the Department of Commerce and applies to commercial products and technology, often considered dual use. For example, an item, a chemical that could be used in the production of a commercial circuit board may also be used as a precursor in a chemical weapon. That's dual use. One of the biggest pitfalls we see is the incorrect jurisdiction and or classification of products and technology. A jurisdiction being whether it's controlled by the State Department or Commerce Department, and classification being whether it's USML or ECCN, which category it falls under within those jurisdictions. So on one hand, if you underclassify, that is incorrectly believing that a defense article falls under the ITAR or the ITAR, or misclassify under the ITAR or the ITAR, you're going to likely end up with a violation. On the other hand, if you self-classify and incorrectly overclassify, that is believing an item should fall under the ITAR, is in fact a defense article or vice versa, you can still end up with a violation from the other controlling agency. And at the same time, you'd be bogging yourself down with erroneous export license applications and so forth. Now, some of these errors are caught on license applications by licensing officers at State Department or BIS and other reviewing agencies, but you can't rely solely on that, as they, the licensing officers, are relying on your classification. Not to mention, only you see the determination if you're using an ITAR exemption or an ITAR exception, so you got to get this right. If you ever have uncertainty as to the correct jurisdiction, there's a process to get a formal decision by the Department of State. It's in conjunction with BIS and DoD, and that's called a commodity jurisdiction, or CJ. That will ensure your classification is correct, and you can rely 100% on a CJ. So ITAR licensing, the bottom line when it comes to ITAR licensing is that if your product falls under the ITAR, an authorization is required, period, for any transfer, whether temporary or permanent. It could require an actual license, such as those mentioned on this page, or it could require a more complicated agreement for defense services, or an agreement covering manufacturing or warehousing abroad, or it could be in the form of a GC, a general correspondence, which is something that is used. It's basically a letter of approval that for anything that sort of falls in the gaps of these licenses. It could also be an ITAR exemption, of which there are many, 50 or more, as pointed out here. About the only defense articles not controlled by the Department of State are those permanently imported into the United States. That's permanently imported into the US. But don't relax just yet, because the BATF controls permanent imports of defense articles. that are listed on the U.S. munitions import list. So that's the USMIL. The USMIL is a subset of the USML and covers primarily guns, explosives, toxicological agents, and the like. So it's a smaller subset of the USML. And as the takeaway says, you always have to verify the end use and end users and obtain backup documentation like purchase orders and end use statements for the transactions. Now let's move to one of the key areas of interest and of importance for you, which is violations and penalties. I'm going to leave it to you to scroll through the violations portion of the DTC website that's listed in the blue takeaway section below to give you an idea of how this can impact your company. I can tell you that I've seen businesses shut down for periods of time while violations are assessed. And while I'm not going to address any specific violations, of which there are many on this website, the DTC website, I highly encourage you to review the compliance actions that are published. I suggest this not just out of some juicy interest to see what kind of fines and penalties have been assessed, though I will admit that is very interesting. Now, more importantly, the published violations are very specific as to what each company or individual did wrong. This is going to help you in guiding your compliance program. You can avoid mistakes others have made. It's really interesting to see some of the same issues crop up again and again on other multiple different companies' violations. And it costs you nothing to review. This is free of charge. It's really one of the best compliance tools that you have. Now, how does ITAR affect your business operations? Well, for one thing, you're going to find that most OEMs now require confirmation that their suppliers of defense articles, that is generally parts and components, are registered with the DTC. This wasn't the case so much in the past, but in the last 5 to 10 years, it's become very, very common. So even a purely domestic operation has got to be registered with the DTC if they hope to work as a supplier to an OEM, for example, building an ITAR-controlled system. So even if you're not currently in that space working, if you're purely commercial and not involved in any way in the defense arena, you may want to be prepared in the event such an opportunity arises, because it takes several months for the registration process. And, by the time you have it in hand, the registration, you may have missed a significant opportunity because if you find out that you need to be registered because you want to get this contract, and then you start the process, you're going to miss it because it takes months. Also, a seemingly innocent error or oversight can cause major disruptions in your business. A violation can lead to fines in the tens of millions of dollars, and that doesn't include your legal costs and other costs associated with a DTC compliance action, like government required audits, hiring a special compliance officer, and so forth. So let's talk about some compliance, ITAR compliance essentials. We're going to focus on specifically on compliance. We're going to detail the sort of the very basic requirements of export compliance when it comes to the ITAR. And I know I've talked about this already, but I just, it's very, very important. And we see lots of issues in this space, which is ITAR registration. I've mentioned that in order to ensure you don't run afoul of the regs, you'll need to be registered with the Department of State. To elaborate on this important issue, a registration with the Department of State is required again, not only for exporters, but manufacturers. So even if you've never exported or don't intend to, If you produce defense articles, you must be registered. Again, as I pointed out in the last slide, most OEMs will now require this in any contract involving USML material. So an important takeaway here is that, as with export licenses, ITAR registration is not something to file and forget. It's an annual requirement, and in fact, they switched it from I think 3 years to an annual requirement just a few years ago. In part, I think because to ensure that you stay on top of it, you don't forget it. And there are a number of easily overlooked reasons why you may need to amend your registration during the year. So some of these things include changes to senior leadership. You need to amend your registration. Acquisitions, divestitures, you need to amend. New USML categories that you're introducing that you hadn't previously listed on your registration, you need to amend. So it's something that we see a lot of problems with. So another area is for a compliance program. You can't have a good compliance program without a good and usable internal compliance plan. So kind of like licenses, as I mentioned, and registration, an export manual gathering dust that's not been updated or not followed is not likely going to help you as a mitigating factor if there's a compliance problem with government. More importantly, a solid compliance plan is going to help you avoid unintended violations to begin with. And recognizing that mistakes are made, the Department of State has a voluntary disclosure process wherein you can self-report infractions. You explain how the potential violation occurred, you explain any mitigating factors, and most importantly, what corrective actions you've taken to make sure a similar violation doesn't occur again. So keep in mind that the DTC also has a directed disclosure process, which, as the name indicates, it is not voluntary, and you're not going to gain any points or sympathy with the government reviewers once with a directed disclosure like you can with a voluntary disclosure. So if you do have an issue, you need to review that and work on the corrective actions, most importantly. And of course, training is a critical part of any compliance plan. Target training based on your company and the audience in question. For example, employees in logistics, HR, and engineering require different training. Think of it as a Venn diagram. All employees require familiarization with the basics, as in this presentation. This is a very basic presentation. However, HR requires a much deeper dive on foreign national issues, logistics on filing export documentations and AS and ACE reports. Engineering has a deeper dive on classifications, jurisdictions, and collaborations with their colleagues. As I mentioned previously, there's no real one-size-fits-all when it comes to compliance. So end user and third-party compliance requirements. There are dozens of denial listings. The only effective way to screen all these denial listings is by subscribing to a service that offers a consolidated screening process. And we can recommend, there's a number, we can recommend some. A party or a country that you may have legally exported to even last week under a license or exemption may now face prohibitions. This is an ongoing process which can change on a daily basis. Again, an automated process built into your ERP system is best. That's really how you want to do this. If you're a small company, you export, once a month. Yeah, maybe you can manage doing it manually, but otherwise you want to have it built into your ERP. And I may mention this a few times, but you have to ensure authorizations are in place prior to export or transfer. You won't get any points from the folks at state or justice if you try to get a license after the fact. Now, another key area is record keeping and audit best practices. Record keeping may be pretty boring, but trust me, you're going to be happy if you have good records. If you're ever under a State Department or Justice Department, or even an internal company audit, these are the key components. Maintain records, maintain the right kind of records, training information and audit history, and also make sure you follow up and document actions you've taken based on the audits that you've conducted. Those are all going to be mitigating factors if you have an issue. So the key point when it comes to international operations or ITAR goods or technology exported or transferred is that the ITAR applies extraterritorially. That is, these regs follow ITAR controlled items outside the US. So again, maintaining proper controls, compliance protocol, and records is really, really critical. So when it comes to cybersecurity, we're all now keenly aware that in our daily lives with our emails and phishing and all that sort of thing. When it comes to in the ITAR context, maintaining control of your data is your responsibility. So for example, if you're hacked, do you have a system to detect the hack? Do you have a way to control access? Where you store the data can be a problem. For example, if your server is outside the US, so even if you have authorization for that, and even if the host technically has no access. So it's a that's a fast evolving area, very, very complicated, but something that you do have to be aware of. And I'll take this opportunity to go back to that the DTC website that I highlighted earlier on another slide. It includes you really need to bookmark that. It includes really good information on so many issues I mentioned earlier, for example, the compliance actions. One of the other areas that is on the website is something called the compliance, their compliance program guidelines. That was updated in 2023, and trust me, it's a terrific tool to help guide your compliance program, including a section on cybersecurity and encryption. I mean, we're here at DSG Global to help. We can walk you through this, but if you really follow that compliance program guideline, you could probably do it on your own. Sorry, Deep. But we'd love to help you. So what are some common compliance risks? I've pretty much focused on this. This is an area that everybody wants to really talk about. Getting back to those compliance actions on their website, the DTC website, you really only need to review some of them to realize that many a company has been fined for unintentional exports of data. I mean, most of these fines are not, there are some where people did something egregious, tried to circumvent the regs, but you'll find that most of the fines and penalties are for companies that were trying to do the right thing. I mean, they were for unintentional exports of data, even just access to controlled data or technology, for example, on a server. This is true even if the non-US party had the ability to access the data but did not. I have seen there are definitely penalties for that. That could be a mitigating factor, the fact that perhaps the non-US person did not actually access it, but it can still lead to significant penalties. And as for foreign national employees, it's not an issue at all as long as you have authorizations in place for any such employees who require ITAR access for their work or those that could have access just by means of their work location. Again, the fact that they could access the technology because of not of their job, but because of where they have where they're located. And as I've mentioned before, as with all authorizations, the license or exemption has got to be in place prior to access. And some final compliance risks, and not necessarily in any particular order. So keep in mind, screening customers and users and other parties is really of utmost importance. And errors in just jurisdiction, misclassification can lead to significant problems. Perhaps most importantly, consider an authorization and your registration as living documents. This is especially true for those authorizations that require ongoing reports or actions such as, for example, annual sales reports, log of exports, etc. Over the years, I've seen many cases where business makes the license application and thus the ability to export the key priority and forgets what's required once the authorization is handed, from the accurate filing of the AES export documentation to reporting requirements and so forth. As Deep mentioned in my bio, I've been in sales in the past and I know how important that sale is, but concentrating only on getting the license and getting that export out the door and failing to follow through post-authorization can adversely impact your future sales and your career. So to sum it up, ITAR is a critical requirement for U.S. national security, and it can help your company's growth and success. And Deep, on behalf of Deep and the entire DSG Global team, I want to thank you for joining us and signing on to this training. Feel free again to contact Deep or myself to discuss your specific requirements. Thank you. And Deep, did you?
Hi, Michael. Thank you so much for that tremendous information that you've managed to encapsulate in half an hour. Just moving on to the next slide. Just Michael, before we go to the next slide, which talks about DSG Global's export compliance services, not an advertisement, but just to list it out there, I just wanted to ask you 5 common questions that our customers ask us. Number one, non-US persons. You've talked about US persons a lot, but could you tell us about the risk of having a non-US person on your shop floor?
Yeah, sure. Well, first, what I want to say is that this is all defined in the regs, but sometimes people think of U.S. persons just as citizen. That's not the case as far as the regulations are concerned. That is, a permanent resident alien, that is somebody who's got a green card, is considered a U.S. person, no different than a U.S. born person for the regulations, or someone who's been granted asylum. And also, by definition, it's a U.S. person or that's an individual or a company. And those of you that are familiar with the commerce regs, this is in the commerce regs, it's called deemed exports, and which I think is a good term because, in essence, providing a piece of ITAR equipment or data, or even again access to it, to a non-U.S. person, someone who's not a green card holder, who's not a citizen, and so forth. That's a violation if you don't have an authorization. So I think that answers that question, Pete.
Yes. Now, in the context of non-US persons, many times our clients ask us, how do we create a technology control plan? Could you just share some light on the importance of a TCP?
Yeah, thank you. Yeah, that's the TCP, as I mentioned on that on the internal compliance plan, the ICP slide. The TCP Technology Control Plan is really critical because um, well, let me just give one brief example. So it will tell you, and it's very much tailored not only for your company but for each site. So you're working for a big company. Um, each site's going to be different. So what the shop floor looks like, the factory floor where the goods are stored, and so forth. So it really can it covers a lot of things, but one of the key areas is how you control the access to the products, the ITAR products and technology. So, for example, you might have on a factory floor where they're producing ITAR material, you might have to cordon off certain areas so that that only U.S. persons can have access to these sections. So again, it's very, very dependent on the particular company and the location.
Got it. Michael, let's talk about CJs. Now, you mentioned commodity jurisdictions as a way to be certain about the jurisdiction and classification of the item. But is it feasible to do it for every product? Could you share some best practices, please?
Yes, that's a really good question. It's really dependent on the company. I mean, I sound like a broken record. It's very dependent on the company, the product, technology. So, uh, but I'll say that in some cases, uh, if the product line is similar, you can create what we sometimes call a Pathfinder CJ. So you can extrapolate in some cases other similar products from one CJ. That's not going to necessarily protect you 100% of those extrapolations, but it can sometimes be more beneficial than a self-determination. Um, of course, in most cases, you can relatively easily self-determine the jurisdiction. And in some companies, there are literally hundreds of thousands of products to do a jurisdiction and classification review. And you obviously can't send 100,000 CJs into the State Department. That won't go over. So, for those of you familiar with the EAR, the related procedure under those regs is a CCATS, and under the CCATS, the BIS is going to confirm the correct ECCN. But one really important warning: a CCATS is never going to protect you if it turns out you had the jurisdiction wrong and the product is controlled by DTC. So a lot of people think, oh, I got the CCCN back and it says it's 9A001. Well, if it turns out that that product is actually under the jurisdiction of the State Department, and that CCATS is not going to help you. I mean, I guess it might help you, but most likely it's not. Did that answer your question?
Yes, Michael, the last question before we wrap up today
Okay.
is on penalties. Now, when you
Mhm.
look at actual violations on the DTC website,
Yes.
you see, penalties going into the severals of millions. Is there any particular format for, assigning penalties that you
Hmm.
can share?
Well, actually, that's a better question for the folks at DTC compliance, but simple answer is no, not that I know of, and I don't think probably anybody knows that. I know it depends on a number of factors. So that they look at because having been involved in a number of cases that were submitted as disclosures in the past over my career, it depends on the seriousness of the violation. For example, is it a national security issue? Is it something that's really, really critical, as opposed to, say, an administrative issue? So, national security issue where some sensitive data is released to a party that shouldn't have that information, or was it a license that wasn't handled correctly? Both are serious, but one is going to probably be more serious and could result in higher fines. Of course, if you have a lot of violations of one type or another, that can also impact the how they calculate this. And one thing that as a non-lawyer, I was not aware of this until I started getting involved in this area, is that one license error, a violation, there can be numerous violations uh, for one apparent problem. So you have a license or you don't have a license, and you export uh, incorrectly or erroneously. If you export 6 times, that could be 6 violations. It's not just one violation. So you might have there might be a licensing error that could result in 50 violations. Well, it's $1 million per violation. That adds up. But the bottom line is there's really no way to know until your case is adjudicated by the government. And that's a very long process. And again, bottom line is that it really depends on the factors of how, national security and so forth. I think that, again, the State Department compliance folks are going to be best to answer that, but hopefully you won't find out.
Good. Michael, the next slide, our last slide, just lists out how DSG Global can help our customers with a whole host of export compliance solutions, both under the Commerce Department's export administration regulations as well as the State Department's ITAR. We provide training, guidance, developing export compliance programs, written procedures, and the whole 9 yards. Friends, the next slide has our contact information. And I'll just wait a second for you all to jot it down. This video is going to be posted on our YouTube channel, and stay tuned for more such educational content. Michael, thank you so much today, and thanks to our audience for taking the time and viewing this. Bye, friends.
Thank you.